Hello, everyone. It's good to have you with us again today for our On the Issues discussions here at Marquette University Law School. Our guest today is Wisconsin State Supreme Court Justice Louis Butler. So let's give a warm welcome to Justice Butler.
Thank you. Thank you all very much. Thank you.
Let me set the stage here briefly. We'll do a quick resume check on Justice Butler. He graduated from Lawrence University and then got his law degree from the University of Wisconsin-Madison. He was appointed to the Wisconsin Supreme Court back in 2004 by Governor Doyle. He is now running for a full term on the court. His background includes having been a public defender, having been a municipal court judge, and having been a Milwaukee Circuit Court judge. So you've done a lot of things.
I've also been an adjunct assistant professor here at Marquette.
So you're familiar with the territory.
Absolutely.
Here. Now, the other thing I have to do before we get started is to say, because we're getting to that time of year where we'll have a lot of political candidates in the hallways here, I need to say that Justice Butler's opinions are merely his own and not those of Marquette University, and that this does not reflect an endorsement of Justice Butler by Marquette University. And in fact, we'll be talking with one of his opponents in January, Burnett County Judge Mike Cableman. So, we've got all that out of the way. Let me say, first of all, welcome, and secondly, are you looking forward to the campaign, particularly because of what happened in the last state Supreme Court race, which was a very contentious one?
Well, looking forward to the campaign might be the wrong words I would use to describe it. I mean, obviously, we have an elective state here in Wisconsin, and I've always been in favor of judges being elected, although I have some concerns from the last race and how elections now look, because I do think there was a sea change there. But there's something to be said about citizens having a say in who's going to make decisions over their lives. And as long as it's Wisconsin citizens making that say, I think it's a good idea. But campaigns are vigorous and they're difficult. And I have the day job. I have a full-time job where we still have oral arguments. We still have conferences. We still have public hearings. I have to write opinions. I have to meet with my colleagues. And, you know, when I'm not campaigning, that ranges anywhere from 80 to 120 hours a week. Now you add a full-time job to keep the job, and what suffers is sleep, family time, and personal time. And so you just kind of have to work through it and say that, you know, at least when April 1st has come and gone, we're looking at 10 years. So.
You said it was a sea change. The
Yes.
last election represented a sea change. What did you think of the race that you witnessed?
Well, I mean, it was the first time that we've seen a huge influx of outside dollars with the express purpose of buying a court. And that's a frightening concept for anybody who cares about an independent, detached, neutral, and impartial judiciary. Judges are not politicians. We're not supposed to be out there trying to run on issues, trying to run on policy-making concerns. I mean, our job is to evaluate the case that's before us, interpret the facts, apply the law to them, and come down with a decision that closely approximates justice. And at the Supreme Court level, we only take the difficult cases. We're not an error-correcting court. We're not like the Court of Appeals. We don't take everything that comes in the door. So we take the tough cases in the front end. We have to make decisions, and those decisions are often unpopular. We're not trying to win popularity contests. So when you talk about the type of money that comes in, and then you talk about the type of campaign ads that we saw last time, and it doesn't matter who you supported. I mean, the campaign ads, I think most people would agree from both sides, were particularly nasty and particularly demeaning from the standpoint of looking at what the judiciary does. I mean, I still picture that one ad that had the full moon and the howling wolf in the background. I mean, this is the Supreme Court, for Christ's sake. That it didn't sit well with me, and unfortunately, we understand that there are First Amendment concerns. People have a right to express their opinions on candidates, but you would hope, and I would hope in the upcoming election, that people will express their opinions in a responsible way, taking into account the nature of the position and what people are being elected to do.
That's your hope. Do you anticipate that will be the case?
We'll have to wait and see.
We will wait and see. But isn't it, I would make the argument that maybe it's inevitable that you'll have a repeat of the last race because there is the perception by special interest groups that there is so much at stake. Is it unavoidable?
Well, the perception of interest groups that are so much at stake, I mean, it's what's at stake. I mean, is what's at stake a neutral and detached judiciary that's making decisions on fact and law is what's at stake, a vote that's going to vote in a particular way every single time. Judges shouldn't be ideologically driven. I mean, I'm not there to make policy. I don't have my mind made up when I walk into an oral argument. You're supposed to listen to the facts of the case. And when people can come in and say, well, I'm going to decide cases in a particular way every time, that should be frightening to the citizens of Wisconsin, because that's when you're there and it's your case that's being heard and it's your argument that's being heard, you don't want the decision made before you've ever opened your mouth.
Do you think candidates should disavow special interest money in races like this? That was a question that we asked both Linda Clifford and Annette Ziegler when they were here last spring for debate on this campus.
And quite honestly, I'm not sure how to answer that question. We do have the First Amendment concerns. Special interest groups have a right to have their say. We understand that. And certainly, if I'm going to be, on the one hand, criticized by big special interest money that's out there that doesn't like the court's decisions, and when I say the court's decision, I mean we're talking about the court as a whole, not just me. But if that's going to take place, then you don't like to be out there by yourself, waving a flag saying, hey, be nice guys. I mean, that's not going to get you very far. So I have some concerns. I mean, ideally, perhaps one thing that we could look at in the future is maybe the media taking a more proactive approach to elections and saying that we have an obligation to make sure that the public's right to know is protected, and that maybe we should stop charging the type of fees that we do and put this on as a public service so you take the money out of these races.
Mm-hmm. Should candidates for the state Supreme Court accept endorsements from various special interest groups? In this race, there will be a lot of those endorsements.
Right.
For example, the Milwaukee Police Association, the association that represents the officers, they've endorsed you.
Correct.
Is that a good thing? Should you accept those, or does it seem like you're saying, or a candidate could be saying, gee, thank you, and I get you, I hear you? I mean, is there a risk in that?
Well, is there a risk? I'm not sure that there's a risk. I think when you talk about endorsements as opposed to some of the other interests that are involved, what you have are people who have experienced the judge or the candidate. They know what they're capable of. They know what they've done when they've served in various positions. For example, the Police Association saw me every day as a municipal court judge and as a circuit court judge. They've had an opportunity to review the opinions. So what they're telling the public when they endorse is that we think that this candidate expresses the values that we care about, that votes independently and neutrally and in a detached manner and impartially, and that we trust that we're going to have a fair hearing. Now, if that's all they're saying, I think that's a good thing. I think for judges who have difficulty in talking about specific issues, because we can't signal how we're going to decide future cases, I think one of the first things that people look at when they're trying to decide who to support is, well, who are your friends? Who doesn't like you? I mean, they need to see other aspects in order to be able to make an informed decision.
You ran for state Supreme Court in 2000 against Diane Sykes.
That's correct.
That was an unsuccessful bid for office, but what did you learn from the experience?
I learned a number of things. One, it's a very big state, and you have to travel and see every part of the state, and I've done that. You also learn, you get some feel for how to campaign on a statewide basis, and what type of campaigns to run. I mean, I made a decision, very conscious decision in that race, that the judiciary is an important position, any aspect of being a judge, that we should not demean it. And so I made a conscious decision to run a very positive, upbeat campaign based on who I was and how I thought justice should be interpreted as a member of the court.
It was a very different kind of
It was
campaign.
a very, very different campaign. And it came on the heels of another ugly race. I mean, the race in '99 involved the Chief Justice and Sharon Rose, and that certainly didn't bring up any feelings of positive attributes from how people viewed that campaign. So I think you learn a lot. You learn who to go to. You learn how to get around. It's also very different, though, running as an incumbent and having served as a member of the court for 3 years, because it's not like I'm an unknown. I have a track record. People have had a chance now to assess my approach on the court for the last 3+ years, and have seen that I have the ability to get the job done, that I understand what's going on, and that I don't have an agenda, and that one of the things that I hope gets through during this campaign is that people will see that the so-called perceived voting blocks that people think that are out there just plain don't exist. I mean, when you look at the voting trends on the court, you have, in the majority of the most on our court, Pat Crooks, which is no surprise. He's been in the majority 97% of the time. But in the last term, I was in the majority second, 87% of the time. And then you have Justice Wilcox and Prosser and Rogan-Sackman and Prosser, and then Bradley and Abrams. And I think if people actually look at, for example, the Zemer analysis that came out in August in the Wisconsin Law Journal, they would be surprised to find that it's not just one block versus another. We do look at each case individually. We do look at the facts of that case, and we do try to apply the facts, the law to the facts as we see them. And it's a very different type of approach from our perspective and how I see it, based on the so-called public perspective, where everybody says, well, you got three and you got three, and then, my God, where's Pat Crooks?
So how would you describe your judicial philosophy?
My philosophy is one of just really going in with an open mind, being one who listens to the arguments, not having an agenda, not trying to decide cases in advance. I think it's inappropriate, for example, for me to come in here and say I'm a liberal, or say I'm a conservative, say I'm a Democrat or a Republican, or anything else like that, because I think I'd be signaling how I want to vote on particular cases, and we're not supposed to do that. We're supposed to make our decisions based upon the facts first and analyze the facts. You really have to get underneath the arguments and to find out why the party brought the case to you to begin with. But then you have to look at our legal structure, and you start with the United States Constitution. You look at the state constitution, which has a glorious history in Wisconsin. You look at the state legislative enactments, because where the legislature has spoken, they make policy for the state of Wisconsin. Where the legislature does not speak, you look at our own common law, which is often the body of law we refer to in tort law. And then you look at our own precedent. And when you analyze that together and you apply the law to the facts, at the back of each one of our minds is whether or not we're accomplishing justice. And that's how I take the case apart and put it back together, and I do it one case at a time. I think that's the philosophy that anybody, particularly at a high court level, ought to have going in. Like I say, it's inappropriate to walk in and say, well, I'm either for this issue or against that issue, or I'm for that party or against that party, or I'm predisposed to vote in a particular fashion on a particular type of issue. Because if we walk in like that, we're not really hearing the parties. We're not really involved in what courts are supposed to do, which is dispute resolution.
Let me have you address then the comments that were made by former Justice Seitz, who's now on the U.S. Appeals Court. And this is not something you haven't heard before, but just for the audience's sake, I'll read it. She gave a speech, actually a lecture here at Marquette University Law School, in which she said she noticed a dramatic shift in the court's jurisprudence, departing from some familiar and long-accepted principles that normally operate as constraints on the court's use of power. The presumption that statutes are constitutional, judicial deference to legislative policy choices, respect for precedent, and authoritative sources of legal interpretation, and the prudential institution caution that counsels against imposing broad-brush judicial solutions to difficult social problems. She seemed to be suggesting that the court has changed, that some of these factors are not being considered in the same way that they perhaps were considered in the past. What's your response to that?
Well, I think to the extent that if she's saying the court has changed because she's no longer on it and I am, and I don't vote exactly like she does, she's accurate. I mean, I think that's correct. I think her perceptions of abandoning precedent or viewing the law in a different manner is incorrect. The reason why you have 7 members on our high court here in Wisconsin, or 9 members of the United States Supreme Court, is because we all come from different backgrounds. We all have different perspectives based on our training, based on our upbringing, based on our experience. When you get the 7 of us in a room, and I'm sure if Diane Sykes was in that same room, if you had the 8 of us in a room, you probably have 15 different opinions on how a case ought to be decided. And we all feel very strongly that we are right and our colleagues are wrong. And it's all about building majorities. It's all about building consensus. It's all about being able to work together and compromise as you're going through and analyzing these cases. And we do come at it from our backgrounds and upbringings. But the net result of what we try to do is we try to analyze the law based on how we interpret it. And I may not agree with Judge Sykes on a given case, and that is okay. I mean, that's why you have 7. If we all thought exactly alike, you'd only need one of us. You wouldn't have to have a collegial body. And we also have to keep in mind that we have a court that really does take only the most difficult cases. We take the line drawing cases. We take the cases that the parties have not been able to resolve and that the courts below are having difficulty in resolving. So when you get cases up there where you're walking that fine line, we may agree or disagree, but in terms of how we approach the law in this aspect, I mean, one of the things that I find somewhat amusing in terms of the direction the court is going to, particularly maybe how I might vote, is most of the time, and as you may or may not know, I'm a prolific writer. Most of the time that I'm writing dissents or concurrences, I'm taking my colleagues to task for not following precedent.
So you believe you're a strong believer in precedent?
I'm a strong believer in precedent. I do believe in following the law. I do understand that there are times when you have to look at whether or not, based on our criteria, whether or not the circumstances has changed, whether or not the law has worked, whether or not the law has an answer. I mean, I can think of one case that I think Judge Sykes wrote about, or may have talked about, excuse me, where there was no answer from the United States Supreme Court. There was no answer from our prior precedent, and we had to come up with an answer, and we interpreted the law based on our state constitution. That's what you do at a high court level, and you can't shirk the responsibility. You can't say, well, I want to decide it this way because it helps this group, or I want to decide it that way because it helps this group. You have to dig down. And one of the things that I like to do, Mike, is I go back and, having been an old appellate lawyer, because I did 9 years of appellate practice, I don't just read the cases that the parties cite. I don't just read the briefs and the cases the parties cite. I read the cases that are cited within the cases that the parties cite. I read the cases that are cited within the cases that are cited within the cases that the parties cite, and I take it right back into the origin of the rule, because that way you can avoid recreating problems that have already been solved by earlier decisions. And one of the things that I find interesting is that depending upon your perspective and depending upon which decisions you're looking at, the type of criticisms that apparently Judge Sykes made are the type of criticisms that anyone can make of any court at any time.
One of your opponents, Judge Gableman, said he will not rewrite legislation. And I think that's obviously meant in reference perhaps to the Dairyland case, where casino rights were the issue, and whether or not casinos were allowed, whether that was really the intent of when voters went to the polls and said we do not want casinos expanded. Now we have casino gambling at casinos throughout Wisconsin. And I think that the point was that really the intent? Did voters actually want that to happen? Did the court rewrite legislation?
Absolutely not. The one thing to keep in mind with the Dairyland decision, and you have to go back, and I always take with a grain of salt criticisms that are made by people if they haven't read the briefs, didn't listen to the oral arguments, and don't understand the cases that are underneath the cases in which we make our decision. But when you go back and you read the Dairyland case, and you read the Dairyland briefs, essentially what happened in that case is you had a 1993 amendment that says that if it's not in the Constitution, there is no gaming. I mean, pretty much that's what I'm paraphrasing, but that's pretty much what the amendment says. If it's not here, if it's not in the Constitution, you can't do it. Well, at the same time the amendment was passed, there was legislation passed by the legislature that was spending the money that was coming in from Indian gaming. The gaming in question was not in the constitutional amendment or the Constitution itself. So you look at the whole body, and Dairyland's point was, and it was a valid point to raise, that, hey, look, if it's not here, then you can't renew these things in 1998. You just can't renew them. And so what happened in the Panzer case, the Panzer case did not analyze the contracts clause. It basically said, well, we don't have to go there. But you had a contract in place. You had the compact. So the long and the short of it is that if Dairyland was correct and the Indian gaming ended in 1998, you couldn't renew the compacts. It was over, and Indian gaming ended in 1998, and nobody was told. The flip side of the coin is that if the compacts were still in place, then the compacts, because they didn't match the language of the amendment, basically the amendment didn't touch the compacts. And if the amendment didn't touch the compacts control. You had a contract in place. You honor the contract. It was a very simple analysis.
Let me ask you to address one other criticism that's been leveled at the court, and that is that I think it was a fairly well-known national publication said that Wisconsin, because of some rulings on liability cases, would become a magnet for trial lawyers. What's your experience with that? Have we become a magnet for trial lawyers because of decisions made by the court?
I find it interesting that the organization and the group that put that out, and I think they actually put billboards around the state, if I remember correctly, criticizing the court in that fashion. It was based on a U.S. Chamber study survey done of in-house attorneys and ranking liability climates here in Wisconsin. Right after I came on the court, there were 2 years where we declined. Well, one of the interesting things about the organization and that survey, there was actually a survey done here in April of this year. And that survey done in April says, according to the in-house members of the U.S. Chamber that look at Wisconsin, that we have the 10th best litigation climate in the country from their perspective. That's how they view Wisconsin and how they view the Wisconsin court system. But you haven't heard about that because the groups that published this so-called, quote, Alabama, the North type approach, all of a sudden got quiet when their new survey came out, and the survey didn't support what they were propounding. So you actually saw for a few months after the survey results were out, still the argument being made that we were going to be a magnet for trial lawyers. No, I think what happens is you have a court system in Wisconsin, and I don't care which level, whether you're talking municipal court, circuit court, Court of Appeals, Supreme Court, or in the federal court. You have a court system in Wisconsin that is dedicated to justice, that is dedicated to doing it, from the judiciary standpoint, doing their jobs. And the judges are out there interpreting and applying the law as best as they can understand it and as best as they see it. And we have outstanding judges in our system. And I'm proud to be a member of the Wisconsin court system. And I have no apologies for anything our court has done over the last few years. I think we have an excellent, outstanding court. I think we have a balanced court by any analysis on, no matter who's analyzing us. And I don't buy a lot of the dribble that's out there in terms of how you break us up. But even if you accept that, we have an outstanding court and a balanced court. And I'm proud to be a member of it.
I want to shift gears a little bit and talk about the fact that you're from Milwaukee and whether or not you feel it is important for Milwaukee to have representation on that court.
Well, I think if you go over to Milwaukee County Courthouse and ask Kitty Brennan today, given some of the budget woes that are taking place right now with the County Board of Supervisors, I think she would think it would be important to have a member of the Supreme Court from Milwaukee. I think certainly it's important to have urban issues, at least an urban perspective on the court when a member gets there, when the court meets and when we sit down and talk, because we do all come from different backgrounds and different experiences. I think it helps to have somebody from Milwaukee. I don't think it's a criteria. And I've said that in the past. But I think it helps that you have people from all parts of the state, from all sorts of different backgrounds, from all different sorts of legal experiences. Because when we sit down at the conference table, we have to really dissect where we're going and look at if we're analyzing a statute, look at the statute based on our different perspectives. If we're looking at a constitutional provision, if we're looking at how to apply it to a fact situation, we have to know how this stuff is going to play out in the courtroom. We have to know how it's going to play out in public. And so it's helpful to have the different experiences. And we've got a broad range of experiences on our court. And I think that's a good thing. I think most people in the state think that's a good thing.
Let me ask you something that it seems almost incredible that I should even be asking you about this in 2007, but you are the first African-American to serve on the state Supreme Court. And if you should win this election, you will be the first African-American to win a statewide office since 1978, when Vel Phillips became Secretary of State. Is race an issue in this race?
Well, that's for the public to decide. I mean, on the one hand, I have to say that I'm honored and I'm humbled to be the first and only African-American to have ever served on the Wisconsin Supreme Court. But I'm also disappointed, and I've said this publicly in the past, because we should not be talking about firsts of this nature in 2007. I mean, this is long overdue. It should have happened long ago, and we should be well beyond that point in time. So, yeah, I mean, I'm honored to be here. I'm honored to do the work of a Supreme Court justice. and I work hard at it. It's been a lot of hours, more so than anybody in this room can anticipate, trying to make sure that the justice is served for the people of Wisconsin. Whether race is going to be an issue for the electorate will depend upon how they view what's going to take place in April and how they view, for example, the outside money that may come into our state in an effort to try to control the court, and how they may view the campaign that may or may not take off based on what we saw last time. I'm hoping we don't see that type of ugliness. I certainly don't intend to run a campaign like that, but I have no control over that. So I think we'll have to wait and see how other resources approach this race to see whether or not the issue of race becomes a central issue in this campaign.
We have a number of young folks in this room who will be lawyers soon. You've chosen to be a public servant. Why did you make that choice? Why not go into a firm, practice law in a large firm? What appealed to you about this choice?
Well, I've always felt, and I think this is important, and different people are here for different reasons. I've got a daughter who's a second-year law student at UW right now. Don't boo, please. So I understand the decisions that they're going to have to make for their future. But for me, I've always approached the law and approached the profession from the standpoint that every individual who went into court had a right to judicial access, a place where they could have their disputes resolved in an intelligent and reasonable fashion, that every citizen that went into a courtroom setting had a right not just to a warm body sitting next to them, but to quality representation, the type of quality representation that one would get if they hired one of the top-notch law firms in town, whether it be Foley or Quarles or Michael Best or whichever. And I don't mean to exclude any of the top-notch firms by not mentioning, there's too many to mention by name, but that every individual was entitled to that type of quality representation. And growing up in a relatively rough area that I did, I know what it's like when people don't have that type of representation, when they don't have that type of a lawyer. And so I look at this, and I looked at my job, whether it was back in the public defender's office or whether it was in the bench, that people were going to get quality representation if I was involved in the case. And that's the way I've approached it. That's the way I encourage new attorneys to approach it. And I don't care who you're representing, or whether you're civil defense or plaintiffs, or whether you're criminal defense or prosecutors, whatever you're out there doing, you should give it your all and work hard. And that's what I tried to do. And so I've taken that very seriously. Public service was always in the future for me. I never wanted to do anything else. I don't even think I applied for any of the law firms when I was in law school. I wanted to be honest with you, I wanted to be a prosecutor. That's why I went to law school. I couldn't get anybody to hire me. I tease Mike McCann about that all the time.
Why couldn't you get anybody to hire you?
I don't know. But I went over and I became a public defender, and I love criminal law. I mean, that was the other aspect. I really did love the criminal law. And it's interesting because on the court now, approximately 75% of the cases we take are civil.
But it's been, describe for me this experience for you, having worked in different positions within the judicial system. What has this been like for you?
It's on one hand, it's kind of like a homecoming because, like I said, I did the appellate practice before, and I love getting underneath the cases. I love being able to not just wing it on your feet, but actually go in, dig in, do the research, find the precedent, find out how precedent has changed over time, and how you can apply it to this particular fact situation. So I love doing that. It's very different than a trial court level, in a trial court setting, because there you've got the hustle and bustle of what goes on in court on a daily basis. You get the interaction with the public. You get the interaction with the lawyers. And we're more isolated at the Supreme Court level. The only people I can really talk to are my 6 colleagues and my law clerk. I mean, and I say that, let me emphasize, law clerk. We only have one. It's a bone of contention on our court. But that's essentially who I can talk to about things, and that's it. So it is more isolating. But the work itself is I can only describe it as being, all-encompassing and wonderful. I mean, I just love doing the job that I do. The supervision of the court system is very different. I have to be honest, when I was appointed, I didn't think in terms of the other aspect, the administrative side of the court. And that takes up a huge amount of time. I mean, whether we're passing rules, whether we're ruling on lawyer discipline, whether we're meeting in open conference, whatever. governing the budget. I mean, there's a number of different aspects that, as an old appellate lawyer, you just don't think about. You think about the case decision process. But that's all part of the job, and I enjoy doing it.
Do you worry that the people in this state simply do not understand what the court does, that it is still a great mystery to so many people?
Well, it is, and I think it's done, and unfortunately, I think the way campaigns are run, it intentionally keeps it as a mystery. I mean, I can't tell you how many slamming jail door cell commercials that people have when they're running for the high court. Well, you know, if you want to slam jail door cells, you know, run for circuit court where you can do something about it. We don't do that at the Supreme Court level. Our job is very different than that. And let's be frank, I mean, for most people, I don't think thinking about a judge is important to them until they're standing in front of one. Then it becomes very important. And so people just don't think about it from the concept of well, you know, who's on the bench until we get close to election time. Then they pay attention to the ads that are run out there. And you know, judicial races are very different from political races because the only thing we can promise to do, if we're doing it right, is to be fair and impartial. That's all we can promise anybody. And these races can be very expensive. People are not going to, we can't ask for a dime, but in terms of our campaigns, when the campaigns go out and try to raise money to run this type of a race, if you can't promise, if you can't deliver on something, you're not going to find donors who are going to be interested in doing anything in that regard. So they're going to go and look at the governor's race. They're going to go and look at the U.S. Senate. They're going to look at the state legislature where hopefully they can get a bang for their buck. So it makes it difficult to try to get a message out about not just our court level, but circuit courts, municipal courts, what the court system actually does as a whole. And that's part of the reason why my job is to travel around the state, to get out and meet as many people as I can, to come to events like this and talk to you, that hopefully we can educate the public as to what the court system does and the fact that this is where people can hope for justice and hope for a dispute resolution mechanism where they'll be heard.
Mm-hmm. Let me take some questions from
Sure.
the audience. It's your chance to ask the Supreme Court Justice. If you have a question on your mind, feel free. Jump in. Yes, sir.
The most fascinating aspect of criminal law. Well, I mean, take it from my background. I grew up in a rough neighborhood in Chicago. I'm here by choice, and as did Dean. I'm gonna put you on the spot here for a second, Dean. Dean Carney, as your next door neighbor, informed me not long ago. Okay. But no, I grew up in a rough neighborhood, and you know, when I was growing up, I know that I felt, and so did a lot of the other young people in my neighborhood, that we all knew where the problems were. We all knew who the gang members were. We all knew that there were issues out there. Why isn't anybody doing anything about it? And so when I went in with the idea of let's go in and clean up Chicago. Let's go in and clean up the neighborhood. Let's go out and do what we can to make this a better place to live. And then when I got into law school, I developed really a love for the law itself, not just what you could do with it, but a love for the law itself. And in the criminal law area, watching the development of constitutional law and how the Constitution is interpreted and applied, that to me is a fascinating subject. And going back and looking at old U.S. Supreme Court opinions or old U.S. Supreme Courts and how they've evolved over the years, or looking at our own Wisconsin Constitution and how it's evolved over the years, I just think it's a fascinating area. Now, that's not to put anything down in the civil area. That just wasn't my focus when I went in. And I'm finding now, as I'm on the high court, that a lot of the civil cases also are fascinating and have an appeal. But I went into it for the criminal aspect. Yeah.
Yes, sir.
You're not supposed to. That's a difficult question because, as you may know, there are not a lot of people out here that do this. And you go out, and I can tell you that I've recruited many people when we were trying to decide who to bring on in our campaign structure. I've met with a number of individuals, both locally and nationally. You go out and you try to find somebody who knows what they're doing, somebody that you can develop a trust relationship with, and somebody who understands about bringing in the people that are going to actually do the day-to-day work, and hope that they understand what's necessary. And then you spend half your time trying to make sure that you walk the appropriate lines. I mean, from the beginning of my career as a judge back in 1992, have taken a very stern approach that judges should not be partisan. We just should not be partisan. And so I've gone out of my way to meet with people on the left and right. I meet with Republicans and Democrats. I meet with conservatives and liberals. I will talk to anybody who will give me 3 seconds and try to explain to them why they ought to return me to the court. And I've gone out of my way around the state to do that. It gets disconcerting when you get pushed back from people. I had a conversation, I won't mention his name because you all probably all know it, but I had a conversation not just a couple of days ago with a former Lawrence grad who was at school the same time I was, who, when I tried to solicit his endorsement, said, well, you're not Republican. I said, it's nonpartisan. But you're still not Republican. And you don't vote the way Republicans. And if you start giving, and this is a quote, if you start giving money to Jim Moody, you can call me. Well, I can't give money to anybody that's in partisan race. I can't give to Doyle. I can't give to Cole. Or I can't give to anybody. But that was the pushback that I got. And when you hear discussions around the state that there were actual recruitment efforts by elected officials of a particular party to recruit an opponent, that gets frightening because we're nonpartisan. And I don't approach the job that way. I really approach the job that we're supposed to be neutral and detached as much as possible, because when we make those tough calls at the end of the day, we have to be free enough to make the decision based on the case and not looking over our shoulders in terms of, well, is this going to get me elected? Is this popular? Is this going to look good? And where it really gets tricky is if we really started doing that, that can impact even the cases we would accept. And that should not be the way you handle a Supreme Court. And so from my perspective, we have got to be independent. We've got to be neutral. We've got to be detached and impartial. And so I try to avoid the partisanship labels. I go out there, and sometimes it frustrates my friends. I can tell you I've had pushbacks from the other side, about you're not enough for us. And it's like, but I'm not supposed to be. And you're not going to hear me promise that. And if you hear a judge promise that, you better start looking in a different direction.
Don't you think it's natural, though, for people to just draw their conclusions, I mean, based on simple things like Judge Gableman, one of his advisors is Darren Schmitz, who's been a long time, a guy in the Republican Party who's helped run campaigns. And then I think the person who is running your campaign works for a firm that the person who runs that firm worked for Jim Doyle. I mean, I think people just draw their conclusions, don't they? Isn't it hard for people not to draw conclusions?
People will draw their conclusions, but it's different when the judge weighs into those conclusions. For example, and I don't want to limit this to a Butler versus Gableman campaign by any means, because there's 3 candidates in this race. There's Charlie Schuetze, too, who was my first opponent. And both of my opponents jumped right, not Schuetze, I see Tom Potter looking over, not Schuetze, Schuetze. But both of my opponents jumped right in their announcements saying we are the conservative alternative to Justice Butler. Well, they're now weighing into it in that fashion. Well, if you want to be nonpartisan, you shouldn't be making those kind of statements.
Mm-hmm. Other questions? Yes, sir.
Considering what you said, would you be in favor of retention elections rather than head-to-head adversarial elections without politics or partisanship?
I think before I would want to move in a different direction, obviously these are constitutional questions. Our Constitution provides for contested elections, nonpartisan elections in Wisconsin. Before I would want to change that, I would probably want to look at some measure of finance reform, whether it be the type we talked about earlier with the media getting more proactively involved, or whether it be the type similar to Senator Ellis's proposal that's out there. I think we should look very hard at something like that. But it does concern me that if you have interest groups that are willing to spend big bucks to control a court, that maybe we'll have to look at this down the road. I'm hoping we don't have to go there. I would really like to work with the system that we have in place.
Other questions? Yes.
We don't take our cases like that. We really wait and see what the parties bring us. Each of the cases that come into our court presents a unique set of circumstances and factors that we have to evaluate. And I don't sit out there, and I don't think the other members of the court are sitting out there and looking at a particular area of law and saying, well, we need to develop this, or we want to develop this, so let's look for a case like this. That's just not how it works at our level. I mean, we get a series of petitions, about 100 to 120 per month, that come in. We have a court commissioner that makes recommendations on whether we ought to take the case or not. We read the petitions. We read the court commissioner's memos. We look at some of the cases that are being analyzed, and then we have to make a decision on whether to take the case or not. So when we're going through that process, I don't think anybody's got the time nor inclination to say, well, we ought to push the law in this direction or that direction, or we ought to look at some particular area that's ripe for review. Sooner or later, they're all going to reach our desk. I mean, that's kind of the nature of the beast.
Sure.
Well, once again, Wisconsin has a glorious history when it comes to interpreting its own constitution. I don't know if you all are aware, but long before Gideon, we had State versus Carpenter, the right to counsel in Wisconsin. Long before the exclusionary rule was applied to the states and MAP, we had Hoyer versus State that applied it here in Wisconsin. We have, over the years, had different expressions from the court in terms of should we look more at our own state constitution, or should we vote lockstep with the U.S. Constitution. The U.S. Supreme Court justices themselves have said repeatedly that you ought to be looking at your own constitutions and evaluating your body of law. We had one particular case that I authored that was a difficult case where you had two U.S. Supreme Court decisions that came down the same day. They were both plurality opinions. So from their jurisprudence, you look at the decisions on the narrowest grounds from the concurring or majority or plurality opinion to find out what the rule of law is in the case. And essentially, the rule was if you have a deliberate violation of Miranda on the one hand, that you could apply the exclusionary rule, and that applies to derivative evidence being a derivative statement. All right. That was Missouri versus Seibert. You had U.S. versus Patain on the other hand that came down and said if you have a non-deliberate Miranda violation, you cannot suppress evidence that's derivative in nature. Okay. We had NAP. We had an intentional violation. We had derivative evidence. It wasn't a statement. There was no body of law that governed us. So we could either make a decision based on the U.S. Constitution where we had no guidance, or we could make a decision based on the Wisconsin Constitution. And we made our decision based on the Wisconsin Constitution. Yeah. Go ahead.
We'll go over there and we'll come back here.
Sure. I think I've been talking about judicial philosophy since I've been here. I think that is an important issue, and I do think we talk about philosophy. I've engaged in that since I've been on the campaign trail, since long before I was on the campaign trail. I think philosophy is fair game. I think partisanship is not. And, we have a court of 7, and it's interesting for those who talk about, and I've heard the pejoratives that are used out there about, you know, do you have an activist court or whatever. But for me, and I think you would, hopefully you would agree with this, for most people, an activist court is a court that has rendered a decision you disagree with. I mean, that's what an activist court is. I mean, I don't care whether you're looking from the left or from the right. If people don't like the decision, they're going to attack it. And it's easy to attack a decision, particularly if you haven't read the briefs, particularly if you haven't listened to the argument, particularly if you haven't done the research, and if you're going to shoot from the hip. And so that's why I say when I hear the critiques of our court, everyone is entitled to his or her opinion. I just would encourage people that before they cast judgments, sit in my shoes. Go out there and listen to the argument. We've got them online. Listen to the arguments. Read the briefs. Go back and do the analysis and do the research and see where you come down and see if what you're doing approximates justice. Yes, but focusing on the decisions, for example, it's easy to attack a decision. It's what, as you understand how commercials work and how campaigns work, it's what you can fit in 30 seconds. And what people are trying to appeal to is the emotional level of the electorate. I mean, that's what people do. People aren't going to sit down and talk about how you analyze a case. They're not going to sit down and talk about what this precedent meant versus that precedent. They're not going to talk about whether or not they've actually reviewed the decisions that are being discussed or reviewed the analysis that the parties brought to the court in the first instance. What they're just going to say is, we don't like that decision, it's unfriendly to this group or it's unfriendly to that group. Because you can get that in 30 seconds and you can appeal to emotion. Well, yeah, it's good if you want to play a shell game. Yes, it is frustrating. I mean, well, first of all, and I don't mean to take issue with the question, but I think the premise of the question is not necessarily the way it really is in real life. I mean, what you have are perceptions out there about where people approach, how people approach the law and where they come down. and then you have realities. And I find you use the last election as an example, and I was not involved in the last election. I know I was going to have to work with whoever was elected to the court, and quite frankly, I had my own election coming up, so I wasn't involved in that one way or the other. But you had an accomplished business lawyer on one side and an accomplished judge on the other. And I think parties, people pushed the perception that one of the candidates was going to be a particular way and the other candidate was going to be a particular way. And I think people bought into that perception. But I'm not sure if either one of them got to the court that they were going to vote exactly the way that people perceived based on what their followers were out there propounding. I mean, you really have to get in and get underneath the individuals. The lawyer in question was a business lawyer that represented big business. It was big business interests that opposed her campaign, which, you know, you kind of sit there and it's like, okay, well, maybe they didn't like her as a lawyer. You don't know what the reasoning is. But so you really have to go through and you have to look at what's being done in the cases, what's being said in the decisions, and how people approach things. I can tell you that I was taken, for example, taken to task by one of my colleagues in 2 opinions at the end of the last term because I wouldn't write big. And by writing big, I mean I wouldn't address issues that weren't before the court that parties wanted an answer to, but it wasn't involved in the facts of the case. It wasn't in the petition for review that was before us, and it shouldn't have been decided by us. And so we based our decision based upon the case and not based upon some big issue because somebody wanted an answer. And that's generally how I approached the cases. And I had people attacking, writing written opinions for not reaching out and doing that. Yet I think many of the people who would try to cast who's in what voting block would say that the person who is pushing for restraint is one who we think writes big, and the person who is pushing for writing big, we think is one who stands for restraint. You really have to get underneath the cases. You have to see what we're doing. And so that's why I say I try to push against this perceptions, this soundbite type approach that, you know, this is what courts do. I mean, what each justice does, and I'll say this for all 7 of us, each of us goes in that room, when we're in that conference room, trying to figure out how our precedent should be applied to a given fact situation and whether or not we agree in its interpretation. A lot of the times we do. You see 7-0 decisions. You see 6-1 decisions. Sometimes we don't. But the times when you'll see 4-3 decisions with unusual voting blocks, nobody writes about those. Nobody writes. I mean, as you pointed out, Rick, I think the way people would perceive it is you're going to have 4 over here and 3 over here. Well, you have 4 very unique voting blocks every time we come out with a decision. And so it's not as easily definable as people would like to think. But I think what people are doing out there is you have different interests that are trying to push their agendas and trying to get people elected who hopefully will vote 100% of the time the way they want them to vote. And that's one thing you're not going to get from me and hopefully not from my colleagues, because that's not what we're supposed to do. We're supposed to make our decisions based on the case.
Time for one final question. Dean Kearney. Fellow Southsider from Chicago. I don't know. You know, as much as my one goal in life that I'll never achieve was to be a professional baseball player, I don't think I ever wanted to go the route of manager. So I think I'll leave that to to Ozzie Guillaume down in Chicago. But the dean I don't think he's embarrassing me. The one nice thing about being a Sox fan, I do not. See, the one nice thing I can say is I can be a White Sox fan and still be a Brewers fan. And that's where I stand. And for those of you who wonder, I am a Packer fan. Okay? How do you feel about the Cubs, though?
It's Northside. You have to go and ask Dean Eisenberg, rest his soul.
I'd like to say thank you very much for spending time with us today. It was great having
Thank
a
you,
chance
Mike.
to pick your brain a little bit.
Thank you very much. Appreciate it. Thank you all for coming out today. I really appreciate it.
And you're welcome to come.